a.m., in Courtroom 3 of the Royal Courts of Justice on the Strand, the atmosphere shifted in a way no one present would later forget. Until that moment, the hearing had unfolded with procedural monotony. Counsel exchanging documents, clerks marking exhibits, journalists recording in silence from the press benches. Prince Harry sat in the witness box facing Madam Justice Margaret Thornberry, posture rigid, eyes forward. He had maintained that composure since the court convened shortly after 9:45 a.m., answering preliminary questions with measured restraint. The case, formally centered on privacy violations and unlawful media conduct, appeared to be following a predictable evidentiary path. Then the judge read a single line from a set of private messages entered into evidence by the defense. "Make him tear up when discussing Diana." The words were delivered without emphasis, in the neutral cadence of the judicial record. Yet, the pause that followed, brief, deliberate, changed the temperature of the room. Court observers later described the moment as airless, as if the space itself had tightened. Prince Harry's reaction was immediate and visible. Witnesses seated behind the bar noted that his jaw clenched, his hands resting on his knees curled inward. His shoulders, held square throughout the morning, dropped slightly, as though a physical brace had failed. Within seconds, the practiced stillness fractured. At 10:15 a.m., he lowered his head and covered his face with both hands. What followed was not loud, nor theatrical. Reporters closest to the witness box described a muted, involuntary sound, half breath, half sob, barely audible but unmistakably human, the kind of sound that cannot be rehearsed, the kind that signals recognition rather than surprise. The courtroom fell completely still. According to multiple accredited journalists present, even the official sketch artist stopped drawing. Pens paused mid-sentence. A senior court usher took an instinctive step forward before stopping, protocol intact. Up to that point, the trial had been framed as a legal dispute, a prince seeking redress against tabloid excess, a familiar narrative in modern British media history. But in that instant, the focus shifted. The issue was no longer solely privacy or press ethics. It became something far more intimate, the apparent collapse of a personal truth under evidentiary weight. The messages in question, as outlined by the defense, were part of a collection of digital correspondence dated between late 2022 and early 2024. They were exchanged between Meghan Markle and a longtime acquaintance based in California, someone described in court as a trusted confidant from her pre-royal years. Portions of these exchanges had been disclosed following cooperation with the defense team. Crucially, the court was informed that these messages were not intended for public disclosure, nor for Prince Harry's review. Their emergence in open court was procedural, not performative, a consequence of evidentiary rules rather than prosecutorial flourish. Justice Thornberry warned the gallery moments earlier that the content would be disturbing in implication rather than explicit in language. As she continued reading, the implications sharpened. The line concerning Diana, Harry's mother, who died in Paris in August 1997, suggested forethought around emotional presentation. Not grief remembered, but grief positioned. Not vulnerability expressed, but vulnerability scheduled. Harry did not look up again. Court transcripts note that at 10:18 a.m., his legal counsel rose briefly, requesting a short recess on the grounds of emotional distress. The request was denied at that time, the judge citing the necessity of maintaining procedural continuity. For those in attendance, it was clear that something irreversible had occurred. The case had crossed an unseen threshold. What had begun weeks earlier as a legal challenge against media intrusion was now exposing fractures far closer to the bone. The testimony unfolding was no longer about what the press had done to Prince Harry, but about what he was now being forced to confront. And as the morning session continued, it became evident that this was only the beginning. What followed the initial rupture was not chaos, but something far more calculated: silence. In institutions like the British monarchy, silence is never empty. It is structured, deliberate, and often more revealing than any statement. In the weeks after internal concerns surrounding Meghan Markle intensified, Buckingham Palace did not rush to deny, nor did it issue the kind of defensive briefings tabloids had grown accustomed to. Instead, it withdrew. Engagement calendars were quietly revised. Informal access to senior aides was curtailed. Even long-standing royal correspondents noticed an abrupt cooling, a subtle but unmistakable signal that the palace was no longer playing on familiar ground. According to constitutional analysts, this silence marked a shift from reactive damage control to institutional containment. Rather than engaging with allegations individually, The Crown appeared to be reassessing the entire framework through which Meghan's narrative had been allowed to operate. This was not about one interview, one contract, or one dispute. It was about precedent. At the heart of the concern was credibility. For centuries, the monarchy's authority has rested less on power than on continuity and trust. Any suggestion that personal narratives, especially those involving lineage, succession, or the commercial use of royal identity, had been manipulated, posed an existential risk. The question was no longer whether claims were emotionally compelling, but whether they were structurally sound. Behind closed doors, sources describe a series of briefings involving constitutional lawyers, medical ethics advisors, and media governance specialists. The discussions reportedly centered on a single principle: verification. Not accusation, not retaliation verification. What could be independently confirmed? What documentation existed? Where were the inconsistencies? And more importantly, who had validated them at the time? This internal audit extended beyond Meghan herself. It examined the systems that had failed to challenge narratives early on, the advisors who had prioritized public sentiment over procedural rigor, and the media partnerships that blurred the line between reporting and advocacy. In this sense, Meghan became less a solitary figure and more a stress test, exposing weaknesses in the modern monarchy's interface with celebrity culture. Notably, senior royals remained conspicuously restrained. There were no leaks attributed to the Prince of Wales, no public expressions of frustration from the king. This restraint, analysts argue, was strategic. Any overt reaction could be framed as personal animus, reinforcing claims of institutional hostility. Silence, by contrast, reclaimed moral high ground. Yet silence did not mean inaction. Legal mechanisms were quietly reviewed. Archival records were re-examined. Even protocols once considered ceremonial were scrutinized for their legal implications. The monarchy was not preparing for a scandal, it was preparing for a reckoning with modern accountability. For Meghan Markle, this phase represented a turning point. Her public influence had long relied on momentum. Interviews begetting documentaries, documentaries begetting deals. But momentum requires friction, and the palace's refusal to engage removed the very resistance her narrative fed upon. Without rebuttal, there was also no amplification. Observers note that this may have been the first time Meghan faced an opponent that did not seek to defeat her in the court of public opinion, but instead stepped outside it entirely. By retreating into process rather than performance, the monarchy shifted the battlefield. The architecture of silence, then, was not weakness. It was scaffolding built to support a future response that would be procedural, evidence-based, and nearly impossible to dramatize. In an era addicted to spectacle, that choice alone was radical. And as the world waited for another explosive revelation, the palace waited for something else entirely. The moment when facts, not feelings, would take center stage. By early spring, the internal review had moved into its most sensitive phase. Documentation. Not testimony, not interviews, paper. According to individuals familiar with the process, what unsettled palace advisors was not a single discrepancy, but a pattern of unresolved gaps, dates that aligned too neatly, records that arrived unusually late, and confirmations that appeared to rely more on assumption than independent verification. None of these elements, taken alone, constituted proof of wrongdoing. Together, however, they raised a question that could no longer be ignored. Had the system accepted narrative where it should have demanded evidence? Central to this phase was timeline analysis. Royal procedures, particularly those touching on succession and the status of royal children, are governed by protocols refined over centuries. Medical confirmations, witness attestations, and formal registrations exist precisely to remove ambiguity. Yet, sources suggest that during the period in question, several safeguards were treated as formalities rather than checkpoints. Legal analysts emphasize that this was not unprecedented in modern royal life. The monarchy, increasingly shaped by speed and media pressure, had adapted its processes to accommodate a more fluid public environment. Compassion, privacy, and trust had become operational principles. But those same principles, critics argue, created blind spots. The review reportedly examined how certain confirmations were issued, who authorized them, and on what basis. In some cases, the answer appeared to be reliance on representation rather than corroboration. That distinction, subtle but critical, became the fulcrum of concern. At no point, according to those briefed, was there an assumption of deliberate deception. The language used internally was careful. Inconsistency, procedural insufficiency, verification deficit. These were bureaucratic terms, but their implications were profound. If processes designed to protect institutional integrity had been relaxed, responsibility did not rest on one individual alone. Meanwhile, the legal ramifications began to surface. Constitutional scholars consulted during this phase reportedly warned that unresolved ambiguities, if left unaddressed, could invite future challenges, not necessarily in court, but in legitimacy. The monarchy's strength lies not in enforcement, but in acceptance. Any doubt, however abstract, erodes that foundation. This is where the matter intersected with Prince Harry's courtroom experience. What he encountered publicly, the messages, the implications, the emotional shock mirrored what the institution was confronting privately, the realization that personal trust had substituted for procedural certainty. Observers note a painful symmetry. Harry, long vocal about institutional failure, now appeared to be facing a different kind of failure, one rooted not in hostility, but in unquestioned belief. The institution, conversely, was confronting the cost of compassion without verification. Importantly, no immediate conclusions were drawn. The review did not issue findings. It did not recommend action. Instead, it catalogued uncertainties, flagged anomalies, and deferred judgment. This restraint was intentional. Any premature move could be construed as retroactive punishment or moral condemnation. Yet, restraint did not mean resolution. By the end of this phase, one thing was clear to those involved. The matter could not remain indefinitely suspended. Sooner or later, questions left unanswered become statements in themselves. As spring turned to summer, the palace faced a dilemma with no clean exit. To act risked appearing cruel. To remain silent risked appearing complicit. And to clarify, truly clarify, would require a level of transparency the modern monarchy had rarely been forced to consider. The documents did not accuse. They did not exonerate. They waited. And in that waiting, pressure quietly accumulated on the institution, on the individuals involved, and on a narrative that had once moved too fast to be questioned. There are few absolutes within a constitutional monarchy, but succession is one of them. It is the axis around which continuity turns, the mechanism that transforms history into future. And when succession intersects with uncertainty, tolerance narrows rapidly. By this stage of the internal review, advisors were no longer debating public relations. The conversation had shifted to thresholds, specifically, the point at which ambiguity ceases to be manageable. In constitutional terms, that point is reached when questions touch the legal status of heirs, however indirectly. Experts consulted during this phase reportedly stressed a single principle. Children must never become instruments of narrative, not for commercial leverage, not for moral positioning, not for institutional negotiation. Their protection is not optional, it is foundational. This is where the matter hardened. While no determination had been made regarding documentation or timelines, the existence of unresolved questions alone triggered protective protocols. These were not punitive measures, but safeguards designed to insulate minors from reputational volatility. In monarchies across Europe, similar frameworks have been quietly reinforced in recent years, reflecting a shared concern about the collision between celebrity culture and hereditary institutions. Sources describe a recalibration rather than an intervention. Titles were not withdrawn, status was not redefined. Instead, access pathways were narrowed. Commercial associations involving royal identity were subjected to enhanced scrutiny. Future representations, particularly those involving children, were flagged for review rather than approval by default. At the center of this recalibration stood the Prince of Wales. Observers note that Prince William's role during this period was notably restrained yet unmistakably directive. He did not brief against family members. He did not signal personal grievance. Instead, he emphasized process. Those familiar with his approach describe it as custodial rather than corrective, focused on preserving institutional guardrails rather than adjudicating personal conduct. This distinction matters. As heir apparent, William's authority derives not from command, but from stewardship. His responsibility is not to resolve conflict, but to ensure that unresolved issues do not metastasize into constitutional risk. In that sense, his involvement reframed the issue entirely. It was no longer a private family matter, nor even a reputational one. It became a question of governance. Legal scholars point out that succession frameworks are designed to function independently of individual intent. They assume good faith, but they do not rely on it. When gaps appear, the response is procedural, not moral. This is why the language of the review remained clinical, even as emotions ran high elsewhere. For Prince Harry, this shift may have been the most disorienting. Long accustomed to interpreting institutional behavior through the lens of personal experience, he now faced an institution acting without reference to emotion at all. The rules had not changed, but their application had become visible. Publicly, this recalibration was nearly imperceptible. There were no announcements, no dramatic gestures, yet insiders understood its significance. The monarchy had drawn a line not against individuals, but against uncertainty itself, and that line was immovable. The children remained loved, acknowledged, and protected, but the framework surrounding them tightened, not as a judgment, but as a precaution. In institutional memory, precautions are rarely reversed. They are absorbed into precedent. By late summer, analysts noted a quiet but consequential shift. Discussions about the future were no longer framed around reconciliation, but around coexistence under defined limits. The question was no longer how to restore trust, but how to function without requiring it. This is the moment many later identified as the true turning point. Not the courtroom, not the documents, but the realization that the monarchy, when faced with uncertainty at the level of succession, does not argue, negotiate, or explain. It insulates. And once insulation becomes policy, the space for narrative collapses, leaving only structure, time, and the unyielding logic of continuity. As February draws to a close, Buckingham Palace is no longer focused on clarifying the past. According to multiple constitutional observers, the institution has shifted into a forward-planning posture, one that assumes uncertainty may never be resolved voluntarily. What remains is not a question of truth alone, but of institutional survival. In that context, the monarchy is now weighing three strategic paths, each designed to protect the crown, even if it permanently fractures the Sussex chapter. The first path is the most confrontational and publicly combustible, a transatlantic legal showdown. Under this scenario, the Duke and Duchess of Sussex would respond by submitting private medical documentation issued by U.S.-based physicians, supported by sworn affidavits, legal certifications, and a coordinated media narrative emphasizing privacy, parental rights, and alleged discriminatory targeting by the British establishment. At first glance, such a move appears decisive, but royal constitutional lawyers have long anticipated it. Under UK constitutional norms, foreign medical rights, particularly those protected by U.S. HIPAA privacy statutes, do not automatically meet the evidentiary standard required for matters of succession. Verification must be conducted under Crown-sanctioned protocols, not third-party assurances. If American records are rejected, the dispute could escalate into a jurisdictional quagmire, pitting California courts against Crown authority. Legal scholars warn that such a battle would be less about evidence and more about power. It could drag on for years, draining public sympathy, freezing titles in legal limbo, and placing Prince Harry in an impossible bind. Defend his family in court, or accept a ruling that quietly diminishes his children's constitutional standing. For the monarchy, this path risks chaos, but it also risks exposure, something the Crown historically avoids at all costs. The second path is far quieter, and arguably more ruthless: administrative erasure by omission. Rather than initiating a public confrontation, the palace could simply proceed without resolution. Names would fade from the official line of succession under the explanation of unresolved documentation. No accusations would be issued, no denials offered. The machinery of the monarchy would continue to turn, as if the question itself had expired. This method preserves decorum while achieving the same outcome. The children would remain members of the family in a private, emotional sense, yet lose all constitutional relevance. To future historians, the absence would speak louder than any statement. It would be remembered not as punishment, but as quiet disqualification, a disappearance, not a scandal. However, palace insiders suggest a third path is now gaining momentum, one that avoids personal confrontation entirely while permanently closing the door. This option involves structural reform through new letters patent, redefining the criteria for royal titles and succession eligibility. Under this framework, the king would not single out individuals. Instead, he would modernize the system itself. Any royal descendant holding the title of prince or princess would be required to be born under Crown-recognized medical oversight and maintain a demonstrable residential and institutional connection to the United Kingdom. The rule would apply universally, without exception. From a legal standpoint, this approach is devastatingly effective. By changing the structure rather than addressing specific allegations, The monarchy neutralizes claims of persecution or bias. The law evolves, and those who cannot comply are excluded by default. No DNA tests are demanded, no accusations are made. The system simply ceases to accommodate ambiguity. Constitutional analysts describe this as a clean-cut solution. It reflects a monarchy that has absorbed the lessons of the past decade, understanding that survival in the modern era depends not on sentiment, but on enforceable frameworks. If enacted, the Sussex children would lose their titles not because of who they are, but because the institutional rules no longer allow exceptions. What makes this moment uniquely volatile is timing. The Sovereign Grant Review, scheduled for the 31st of March 2026, transforms this issue from symbolic to material. Without verification, funding mechanisms stall, security provisions weaken, administrative recognition evaporates. Biology, law, and finance converge into a single pressure point. Behind palace walls, the tone has reportedly hardened. Silence is no longer passive, it is strategic. Each day without compliance narrows the available exits. Draft policies are being finalized. Legal memoranda circulate between the Privy Council and the Home Office. Contingency plans are no longer theoretical. This is no longer a story about rebellion, celebrity, or modern love. It is a story about governance. About whether a 1,000-year-old institution can tolerate uncertainty at its core. History suggests it cannot. When the Crown stops negotiating, it does not announce it. It simply moves forward and leaves the unresolved behind. By the time the High Court proceedings adjourned and the courtroom doors closed, one truth had already crystallized inside the British establishment. This crisis would not be resolved by emotion, reconciliation, or public sympathy. It would be resolved by structure. And structure, in the monarchy's language, means law, precedent, and irreversible decisions made quietly, far from cameras. The Crown has faced scandals before abdications, divorces, leaked tapes, even constitutional emergencies. But what set this moment apart was not scandal, it was ambiguity. An unresolved question at the heart of succession is not merely uncomfortable, it is existential. Institutions built on continuity cannot survive uncertainty embedded in their bloodline. According to constitutional historians, the monarchy operates on a single, non-negotiable principle. Legitimacy must never be debatable. The moment legitimacy becomes conditional, the Crown ceases to function as a stabilizing force and becomes a subject of endless dispute. That is why, behind palace walls, patience has quietly expired. Sources within Whitehall confirm that by early March 2026, contingency frameworks had already been finalized. These documents do not name individuals. They do not reference scandal. They are written in neutral legal language, designed to withstand judicial scrutiny, parliamentary debate, and international observation. Their purpose is simple: to ensure that never again can the monarchy be placed in a position where proof is requested after recognition has already been granted. At the center of these preparations lies a fundamental shift in philosophy. For centuries, royal legitimacy relied on trust. Trust in lineage, trust in declarations, trust in tradition. That era is ending. The modern monarchy, shaped by media saturation, global scrutiny, and legal activism, is moving toward verification over faith. This evolution places Prince Harry at the most painful intersection imaginable. He is not merely a son caught between loyalty and love. He is now a variable in a constitutional equation. His silence, once interpreted as dignity or shock, is increasingly viewed by insiders as paralysis. And paralysis, in governance, is fatal. Palace aides describe the atmosphere as procedural, not punitive. No one speaks of revenge, no one celebrates exposure. Instead, there is a collective understanding that damage control has already given way to future proofing. The monarchy is no longer reacting to events. It is preparing for a world in which emotional narratives no longer outweigh institutional clarity. What does this mean for Meghan Markle? Contrary to public speculation, the Crown does not view her as an adversary to be defeated. It views her as irrelevant to the final outcome. Monarchies do not engage in personal battles. They outlast them. Her intentions, whether strategic, defensive, or desperate, are ultimately beside the point. The system does not judge motive, it judges compliance. If compliance does not come voluntarily, the institution proceeds without it. For Prince Harry, the consequences are far more intimate. Over the past decade, he defined himself through rupture, leaving, rejecting, exposing. But this moment demands the opposite. It demands submission not in spirit, but in process. To cooperate now would require accepting rules he once denounced. To resist would mean accepting that his children's royal identities may dissolve not with outrage, but with administrative silence. This is the cruelty of systems. They do not argue. They simply continue. Senior royal commentators note a striking pattern. Every public statement issued since the courtroom revelations has avoided emotion. Words like family, love, and forgiveness have been replaced by process, review, and future alignment. This linguistic shift is not accidental. It signals closure. The monarchy is no longer framing this as a domestic tragedy. It is framing it as an operational correction. And yet, despite this institutional hardening, the human cost remains visible. Prince Harry's courtroom collapse, documented in transcripts, eyewitness accounts, and global broadcasts, has left an imprint that cannot be erased. For many observers, that moment reframed him not as a provocateur, but as a casualty. A man who believed he was reclaiming agency, only to discover that agency had been curated, coached, and monetized around him. Mental health experts have weighed in